Welcome back to Prospect Channels TV. My people, we don't come back with another Ubonge update. This one now concerning Nnamdi Kanu and his trial versus Nigerian government. So his lawyers, they don't review. Waiting to happen on the June 13th. Recall that Nnamdi Kanu will be returning to court on 13th of June. That is this week, Friday. So Kanu's legal team, they don't drop prophetic bombshell. They don't talk. They don't check out how this matter could be. Because when you look inside the matter, you go understand, say, the Nigerian government prosecutors, okay, they not get strong case against Nnamdi Kanu. Nnamdi Kanu don't they win them already. So my people, make I drop this video. We go watch her together. If today be your first time, subscribe, share this video, make it go viral, so that dear friends, we understand what is happening today. Thank you. See you in my next video. Bye for now.
It is divided into three parts and several subparts, which will be discussed under an introduction, an analysis, and an executive summary. Now to the introduction. Nnamdi Kanu's case began in earnest on October 14, 2015, when he was arrested on his arrival in Lagos from his location in the UK. The reason for this arrest, as it was alleged at the time, was due to broadcast he made from his location in the UK, comprising basically of his demand for the restoration of Biafra. He was then charged with treasonable felonies and other minor offenses. But later in time, Nnamdi Kanu was granted bail twice by two different courts, but the government of Nigeria disobeyed or otherwise unlawfully parried the court orders, and he remained not obeyed. However, much later, in April 2017, Nnamdi Kanu was eventually released on bail. Such was the case that on 16 December 2016, when the federal government withdrew all the charges filed against Nnamdi Kanu before the Chief Magistrate Court in Abuja, leading to the charges being dismissed also, and Nnamdi Kanu being thereby discharged. It will be recalled that these charges also were at that time dismissed. But the federal government doubled back and charged them back before the Federal High Court at this time. Beyond continuing to detain Nnamdi Kanu in disobedience of court order at that time, to the contrary, the federal government also did the unthinkable by arresting Justice Adeniyi Ademola, who had ordered unconditional release of Nnamdi Kanu at that time. According to several newspaper reports of 15th October 2016, Justice Ademola had stated, and I quote, "From the time of my arrival at the DSS office at about 6:45 p.m. on 8/10/2016, I was not told what my crime was for over 24 hours. Till the evening of 9/10/2016, a DSS officer officially finally informed me that the search of my arrest, that the reason for my arrest was based on these three allegations. One, petition of Hon Jenkins Duvier, dated 4th of April 2016 to the National Judicial Council. And two, granting bail on Sambo Dasuki. And three, the unconditional release of Nnamdi Kanu. This was perhaps one of the earliest telltale signs that Nnamdi Kanu was in for a rough ride with the darkest side of the Nigerian criminal justice system. Consequent upon his grant of bail in April 2017, he proceeded to his ancestral home in Afaruku, Ibek, Umuahia in Abia State. For someone enjoying his bail and awaiting his next court date, It therefore came as a surprise, deadly surprise indeed, that beginning from 10 September to 14 September, the Nigerian Army and other security agencies launched lethal military invasion of Nnamdi Kanu's ancestral home, where he was staying with his members of his family and well-wishers. It was indeed a deadly assault that claimed at least 28 innocent lives. Nnamdi Kanu and his parents, who were on location, sustained injuries, and his parents later succumbed to those injuries, and they are now deceased. Well, it is there, as they say, the rest is history, that Nnamdi Kanu, in order to save his life, had to depart the territory of Nigeria in search of a safe haven overseas. You will also recall that sequel to this attack, Nigerian Army did not let off. They announced a nationwide manhunt of Nnamdi Kanu. And the immediate aftermath of that invasion, infamous invasion, Nigerian government promptly commenced a constitutionally questionable administrative action to proscribe IPOB and declare it a terrorist group. This decision was preceded by the infamous public declaration made by the Southeast governors on 17 September 2017. And accordingly, following these public declarations by our government officials, on 20th September 2017, late Justice Kafrati of the Federal High Court granted the federal government her wish in an ex parte application brought before the justice by the former Attorney General of the Federation, Abubakar Malami, SAN. Apparently, in taking the decision to proscribe IPOB and declare it a terrorist group, neither the Southeast governors, who fired the first salvo, nor the federal government had recourse to Section 42 of the Nigerian Constitution, which is a fundamental right, a section guaranteeing the fundamental right of every Nigerian against discrimination based on ethnicity. I'm saying this because later in time this matter went to court, and the High Court of Enugu State, in a landmark ruling, pronounced the executive action or administrative action leading to that prescription as violative of Section 42 of the Constitution, based on some ethnic considerations against the Igbo. Thus, by the plain provisions of that section, members of IPOB who largely hail from the Igbo tribe were generally criminalized. So, to be clear, the practical application of any law enforced in Nigeria, including the Terrorism Prevention and Prohibition Act, or any criminal justice statute or legislation, has to be applied even-handedly across the board to all Nigerians without discrimination of any sort. But in this very instance, IPOB, having been perceived as springing from the Igbo and their cousins in the southeastern part of Nigeria, was singled out for the special act of discriminatory proscription and declaring it a terrorist group. Of course, this gave the federal government the legal license to direct its armed forces to resort to the rules of engagement, which required it to shoot to kill, not even shoot to maim anybody perceived to be a member of IPOB, and this has continued to this day. And of course, that was what culminated in the extraordinary rendition of Nnamdi Kanu from Kenya to Nigeria in 2021. It therefore follows that by failing to take action to proscribe other similarly related ethnic organizations, such as the Fulani Headsmen or Mietiala, or Udua People's Congress, or Niger Delta Avengers, some of which are known to have borne arms and carried out violent attacks, but the federal government did not as much proscribe them or declare them terrorists as it did IPOB. It is our position, and which was confirmed by the court judgment I referenced, that the proscription was highly discriminatory. Now, in summary, the right guaranteed under that section is unarguably and essentially a right to freedom from any discrimination of any sort based on national origin or ethnicity, such as has been levied against the IPOB and its members, perceived or real, by the federal government since October 2017. The declarations made by the court are 3, and the orders issued 2. The court declared that action unconstitutional. It also declared that what IPOB is engaged in, the enterprise, is known as self-determination and that it is not unlawful. And the court, because the action offended its conscience, awarded $8 billion against the federal government for that action. It therefore came as a double whammy that in the next few days following the proscription of IPOB, the Attorney General of the Federation underscored the constitutionally prohibited finality of the action by gazetting it, and therefore criminalizing millions of Igbos who are perceived to be members of IPOB, whether the perception is real or not. And it also led to interdiction of their properties, money, and otherwise wherever found. It's also led to mass arrests, extrajudicial killings, torture, detentions without trial, and whatnot. Now, in March 2018, the African Union, through its African Commission on Human and People's Rights, which administers human rights adjudications in the continent of Africa, held against the federal government that the proscription was wrong under the African Charter, which bound Nigeria. Nigeria ratified the African Charter in 1983, and from that date it is bound by it. So this African Commission on Human and People's Rights had clear jurisdictions to decide this case, and it decided against the federal government and wrote a strongly worded letter to the then president of Nigeria to retrace his steps and restore IPOB to its former legal status and cease and desist from further arresting or harassing or persecuting members of IPOB. Yet, from the date of issuance of that decision to when the former president left office, nothing was done. Rather, the opposite was done. The persecution, prosecution, arrest, torture, everything became even worse. It is pertinent to mention at this juncture, perhaps as a necessary digression, that had the former president of Nigeria implemented that directive issuing from the African Union, a lot of people who died numbering in hundreds, some say in the thousands, and in fact, including Nnamdi Kanu's infamous extraordinary rendition from Kenya in 2021, wouldn't have happened. A lot of lives would have been saved, and the nation would have been more at peace. And we will not have the insecurity that we are grappling with today in the Southeast. And further to the decision of the African Commission on Human and People's Rights, the United Nations, through its special rapporteurs, transmitted a decision in 2020, May precisely 2020, no, in October 2020, condemning the proscription, IPOB, and the terrorist tag placed on it. The quotations of what they said are contained in our press release, and they are verbose. But the summary of what they are saying is that the action of the federal government was driven by some ethnic considerations against the Igbo, and that the action offended every known canon of international human rights law. Consequently, this organ, which is a very important organ of the United Nations, directed the federal government to do the opposite by deproscribing IPOB. That the action was never taken to get that done, and so here we have it, that for quite some time now, these things have persisted, and here we are with the dramatis personae, this most single factor in this whole saga is Nnamdi Kanu, who remains in detention to this day.
All right, guys, thank you very much for staying to the end of this video. So on the 13th of June, which is this month, on Thursday is another day, we will see how Nigerian government go take out command for this matter. So now here I go drop on. Share this video, make it go viral. Like us, and don't forget to drop your comment below the comment section. Bye for now.